Hello everyone, thank you for joining us today for our Management Liability Webinar with Chris Bolin, and we are really excited today because we have a special guest speaker, Peggy Hennen from C.N.A. So I will turn it over to Chris without further ado.
Thank you, Elizabeth, and thank you all for joining us today. I know everyone's pretty busy, so we're going to try and keep this to about a half hour for you. Basically what we're going to be talking today is we're going to do an overview of management liability insurance. Think of this as Management Liability 101 for you. Just looking at the attendee list, I see a lot of newer producers for us, so hopefully you guys can learn something new today. If there is any specific marketing information that you guys need after this is over, I am going to provide some contact information, and we can send you anything you need there. And just so everyone knows, we're also going to have a small Q&A opportunity at the end. We're going to try and answer any questions we get, but if we don't have the time or the availability, I will personally respond to everything via email or phone call later this afternoon. So with that said, let's go ahead and dig in. When we're talking about management liability, there are basically 5 coverage parts that we're focusing on. As you can see up on your screen there, there's the directors and officers, the employment practices, fiduciary, crime, and the kidnap ransom piece. These are all very important, and they're the core coverage for your management liability. One thing I want to point out before we kind of dive in is that the management liability products offered by all of our carriers are pretty unique because any of those coverage parts you see up there can be mixed and matched on the policy form. So if you've got someone who just needs D&O, we can write that as monoline. If you need someone who needs just the EPL and the crime, we can group those together on the same policy form. And most all the carriers we deal with do have the flexibility to do that. We actually deal with over 30 different carriers here at Stuckey & Company, and some of them are program specific, some of them are not. The screen you're looking at, the slide you're looking at there, those are our top management liability markets. We realize there's a lot of competition out there, and I do want to point out too, I know some of you have direct, paths to some of these carriers. So if you're sending us a submission, make sure you let us know. Like, for example, if you already work with Philadelphia, let us know because, when we get submissions in, we might know some cases where certain carriers' rates might be higher or lower than others, or there might be some deductible availabilities, things like that. So let us know when you send it in if you use any of these markets already, and we can make that adjustment for you. Okay, basically, the first of the 5 coverages I want to talk about is the crime section. What we're talking about here are things like your employee theft, your burglary, forgery, and embezzlement. Keep in mind that it's 2012. We're seeing a lot of white-collar crime issues, a lot of employee dishonesty, and computer fraud is a hot topic today. Think of it like this. I mean, if you've got a company, you could have a trusted employee within your organization that could be embezzling funds, stealing inventory, committing fraud, and this could take place over a long period of time. And I'm not going to go into specifics, but this is actually something that recently just affected me. I live in the St. Louis area and just moved into a condominium. And on our board, we actually had a guy that was embezzling funds for several years. And it was discovered, and of course, he's being prosecuted. And to date, over a 3-year period, our condo association lost over $50,000. And that's not counting, the costs to prosecute and go through the legal process. Right now today, he actually has been sentenced, but the cost incurred to us was over $100,000. So the point I want to make is that this happens more commonly than you think, and people probably get away with it more than you think. It can happen in private companies, associations, or non-for-profits, so keep that in mind. Some things to consider when you're talking about the crime portion. I know a lot of times when you're shopping for a package policy, you can see the crime coverage usually sublimited within the policy. One thing the point I want to drive home here is, as the producers, you guys need to know what you're getting in your package policy. if you read those last 4 bullet points there, I'm pointing out some things to be aware of. Coverage can be restrictive. You might have some lower limits, less specific coverage wordings, things like that, and it lots of times creates a need for a true crime policy. And especially that last bullet point there, a lot of these policies may not even cover things like your computer or funds transfer, credit card fraud, things of that nature. So just keep that in mind. Moving on to the next slide, fiduciary liability. Basically, we're defining a fiduciary as a person or entity with authority to act on behalf of others and obligated to meet a high standard of conduct. Responsibilities of fiduciaries are defined by ERISA, which is the Employee Retirement Income Security Act of 1974. And basically, it's defined to protect fiduciaries of pension and benefit plans covered by ERISA from claims they breached their obligations to the plan. So what does that mean? Basically, this is defined to protect fiduciaries of pension and benefit plans covered from ERISA. Consider this. Retirees, former employees, current employees can all sue a company and its plan fiduciaries for alleged mismanagement in administering benefits. So there's a pretty large exposure just within that realm. Again, like I was talking about with the crime portion, it's important to check the coverage you have now. Like I was mentioning in the GL portion earlier, the intention of a GL policy is not to cover fiduciary claims. Basically, the employee benefits section of a GL policy protects only against claims of E&O in plan administration only. Most will not cover breach of fiduciary duties under ERISA. And then that second point there, the ERISA bonds, keep in mind that those usually only cover actual theft. I usually recommend to people when they're looking at management liability coverage to always group your D&O and your fiduciary together. Why? Because your D&O usually excludes claims for both your EBL and your breach of ERISA fiduciary duties, and the EBL, of course, being your employee benefits section. Kidnap and ransom. Really not the most pleasant thing to think about. And when you mention this coverage to your clients, if you're like me, usually the first thing that pops in your head is that worst case scenario. You think about where we are in the world today with stuff going on in the Middle East and things like that. You think of Hollywood and the guy coming and kidnapping your family and all that nastiness. But a lot of times, no one thinks about the extortion portion of that. The coverage for kidnap and ransom, as you can see in that first bullet point, the idea there is worldwide exposure. But think about all the companies just in the United States that can have extortion threats. There are huge technology companies. This can happen in your backyard, and I always think that's a very important coverage to look for. And kind of a fun thing to twist this around, every single carrier we deal with when we're talking about kidnap and ransom, they have some sort of process in place to come in and help out in a true, what I'm going to call danger situation. And I'm just for fun, I'm going to point out what Chubb does. I don't know if any of you have ever seen a movie called Proof of Life. It was kind of loosely based around this. But Chubb uses a company called the Ackerman Group. And basically what they are is they're specialists in counterterrorism. They've been around since 1977. And if you've got a situation where you need to use this coverage, let's get real. Do you want your insurance underwriter sitting at a desk dealing with a kidnap, a ransom, or an extortion drop? Probably not. So what they do is they contract out to companies like this. These guys are like, ex-Marine paramilitary types. And they're prepared to go in a crisis situation, and basically they handle all aspects of it. Hostage recovery, negotiations, acting as a liaison with law enforcement. It's kind of scary stuff to think about, but that coverage can be very important. And we're starting to see more and more, too. This is a global economy. People are traveling outside of our borders. and even, like I said earlier, even within our borders, there are definite exposures here, and that's not even just mentioning the extortion. And at this point, I think I'm going to turn it over to Peggy Hennen. She's going to talk about our directors and officers and EPL portions here. Peggy brings about 17 years of underwriting experience, and she's the lady. Let's go.
Thank you, Chris. I appreciate it. We're going to start with directors and officers liability. I think it's one of the least understood management liability lines in that private companies really don't feel that they have the exposure, that they don't need to purchase directors and officers liability insurance, and that is clearly not the case. Directors and officers can be sued over their day-to-day decisions, the decisions they make because of their ownership in the company or simply because of their status with the companies. Private company directors and officers can be sued by many potential plaintiffs, including their investors, shareholders, customers, clients, and any one of the others listed in this slide. You'll notice that shareholders is only one of those many persons that can bring suits against the directors and officers. And therefore, privately held companies need this insurance as much as publicly held companies. Some common D&O allegations. When most people think about a D&O claim, the first thing that comes to mind is, again, a shareholder lawsuit. But this slide lists the most common D&O allegations that private companies may experience. And we'll just take a minute to review them. Breach of fiduciary duties under the applicable laws. That is not saying that it's going to cover what a fiduciary liability policy will cover, but there is some coverage for a breach of those duties. Mismanagement of the business or operations, wrongful interference with a contract, failure to perform appropriate due diligence in decision-making, misrepresentation or errors regarding the financial health of the company, disclosure or misleading information, misstatements, or omissions regarding potential future performance, unfair trade practices, minority shareholder oppression, and conflicts of interest. You can see from these allegations that this is not just a shareholder concern, that the unfair trade practices might come from a competitor. You have employees, you're going out and getting the best employees that you can. Well, those employees work for a competitor. And that might be an allegation that's made that a D&O policy would respond to. Some common misconceptions about D&O insurance and many of the management liability coverages, like we discussed for fiduciary liability, is the general liability or your umbrella policy is going to cover these types of claims, and it's not. That's not what a D&O. That's not what a general liability or an umbrella policy is designed to cover. Second, private companies can rely on being a one big happy family as a risk management strategy. After all, even the closest families have disputes. I think divorce is something to bear in mind when you're talking about one big happy family. And again, it's not just shareholders and employees too. Can everyone hear us at this point? I guess you can't respond. So we're just going to go ahead. We've heard some feedback. Just want to make sure as best we can that everyone is hearing us. It appears that we are. Okay, so what exactly does a D&O liability insurance policy provide? I can speak for C.N.A. The EPAC D&O policy provides coverage for D&O activities as well as the entity coverage to protect the assets of the company. EPAC and many others out there, and this is what you want to look for, is a duty to defend policy. Chris talked about during the crime presentation, the cost of defending oneself many times far outweighs what the settlement was or what the actual loss was. And therefore, it's the duty to defend the experience that we bring to the table as an insurance company, so that the Ds and Os can focus on running their business rather than defending against these costly lawsuits. In addition to a broad coverage form, some additional enhancements are available to qualified insureds, such as defense outside that limit of liability, an additional $1 million coverage for non-indemnified losses, and a zero D&O retention might be available. These are just some of the things that you want to look for in a D&O policy. Moving on to EPLI. EPLI is the money. EPLI is where the majority of the claims are going to be. EPLI is the go-to coverage for most brokers. That's understandable. You know, you can see it in the news. Sexual harassment, discrimination, wrongful termination. You know, those are things that are easily understood. But again, privately held companies feel insulated from these kinds of claims, and that's completely wrong. Employers do face a growing multitude of serious employment practices exposures. On this slide, we see suits can be brought by their employees, full-time, part-time, independent contractors, seasonal, volunteers, pre-employment candidates. This has always been a rough one for me, that someone that you haven't even hired yet, someone applying for a position, there is the failure to hire that a private company needs to insulate themselves from, and third parties, your clients and your customers. Some common allegations that employers will face which fall within the employment practices liability area are harassment, which is a subset of discrimination, unwelcome conduct based on an employer's protected class, which is a severe or pervasive and affects working conditions or causes an offensive or hostile work environment. Discrimination, treating an employee in a protected class differently than others outside his or her protected class. Remember, you can treat employees differently based upon valid business reasons, such as performance. What you can't do is discriminate based upon reasons that are protected, such as race, gender, age, disability, religion, etc. A growing number of protected classes. Wrongful termination, on its own, not a cause of action, as most employees are employed at will. However, you will often see wrongful termination alleged in conjunction with a discrimination claim or an allegation of a violation of public policy. Breach of contract, action taken in violation of the terms of an employee's contract. Defamation, the unprivileged publishing of false information that injures a person's reputation. It's commonly referred to as libel, which is a written communication, or slander, oral communication. And with, you know, Facebook and all the social media out there, I do really believe that this is a growing problem that employers need to get ahead of. And then there's negligent hiring, retention, and supervision, where you have or should have had knowledge about an employee and failed to act upon it, and that employee harms another employee. Some of the statistics that can be found on EEOC.gov, one of my personal favorite sites. This is in 2011, you know, business owners are at risk for the decisions they make regardless of what industry they're on. Many people think falsely that the service industries are the only place where you're going to find third-party claims or EPLI claims, and that's just not the case. It goes across all industries, manufacturers, wholesalers, contractors. Every industry has been touched by an EEOC claim. Below you'll see some of the highlights in the statistics, and they add up to 100% because there might not be just one charge. So didn't want to confuse anybody, but there are multiple allegations. Retaliation, race, sex or gender, age or disability. These are some of the highlights that the EEOC has pointed out. Some current issues we discussed briefly are there's a lot of friction between the generations in the workplaces. They're vastly different. The aging workforce is an issue that arises in various situations, including training and disability accommodation. Social media, as we discussed before, is a major concern. Prohibiting its usage while at work on company computers does not resolve this concern. Employees can still access Facebook or Twitter from their home computer, and their actions may cause you to lose valuable confidential information. Textual Harassment is a new concern as many employees routinely text messages to one another. To create a policy that governs the use of social media, which should include a definition of social media and what is acceptable and unacceptable use. Unacceptable use may include statements that create an unfavorable public image of the employer, disclosure of confidential information, or statements which could be deemed harassing or defamatory. You should consult with an attorney to make sure that your policy complies with federal and local law. Wage and hour litigation is on the rise, and it's more important than ever that you reevaluate your employees' exempt and non-exempt status. Keep your eye on trends and new legislation. Discrimination charges are an all-time high just over the past 2 years. The EEOC and Department of Labor have received increased funding and are pursuing these claims more aggressively. If you do purchase an EPL coverage, you will be provided with web training. Many of the EPLI policies I'll speak towards C.N.A's, which has human resource online web training, which can help the insured stay current with timely information on recent laws and issues. And these come with your EPL policies.
Perfect. Thank you, Peggy. And I do want to talk a little bit more about some general overview kind of stuff as well. You guys are on the front lines out there with the applicants, and there's some other things that I think come into play here. And this varies from carrier to carrier, but things like offering some free claim assistance for people with EPLI. Let's get real. Most of these companies are not lawyers. They don't know what they should and shouldn't do. Sometimes by their not acting, it could result in a much larger claim. And some carriers will offer some free claim assistance. And as far as helping you sell, close the deal, I'll use C.N.A. for example. If you purchase the professional liability and a management liability policy, you actually get a premium discount on that. So it's, even if it's two separate forms, you're getting a premium discount for grouping it all together. I always get asked about, what do I need to quote, things like that. Just some general underwriting requirements up there. I mean, I'll let you guys read it yourself, but we need an application. Without that, it's almost impossible. We get people on the phone all the time. These risks are generally very easy to quote. Most carriers can quote off of a competitor's application, but the key here is we do need a completed application. Without the underwriting criteria, we're not going to be able to get very far. And sometimes, if we do ask you for some supplemental information, there's a reason for it. And even if we're only dealing with one market and you ask us to shop it, they're probably all going to ask the same things. Like, for example, I'll pick on California. EPLI is, it's a tough market in California. Sometimes we might need to look at, say, the non-discrimination wording as part of the employee handbook. Again, there's a reason for it. Maybe it's for a premium discount. Maybe it's just to see if the risk qualifies at all. But just know that there's a reason if we ask for something like that. Minimum premiums. Again, I realize that all of you are, face-to-face with our applicants in many cases. Everyone wants to know what's it going to cost. The short answer is not the best answer. It's hard to tell, which is another reason sometimes we're picky on the applications. I cannot even tell you how many times in the past I've answered a phone call to tell someone, oh yeah, your minimum premium for something like that is probably going to be about $1,500. Then we get the submission in and find out there's claims. They don't have good risk management procedures, or they're in a different geographic location than I was originally aware of. Next thing you know, I'm giving you a quote for $6,000 and I'm the bad guy. So we try to avoid that, but the more info, the better. Again, that ties into the last slide. It's just underwriting info. The more we have, the better we're going to be able to accommodate you with the best pricing and coverage out there. Commissions, again, I know you guys, we're all in it for the money. We wouldn't be doing it without that. The commissions do vary on the management liability program here. It varies by the carrier and the product itself. In some cases, we're allowed, or we're able to pay a little bit more for new business than renewals. The best range I can give you as far as a reasonable expectation is that we pay between 10 and 15% commission on placement for management liability. And I would venture to say that the vast majority of those are about 12%. So realistically, that's what you can expect. I would say 12 is probably a reasonable expectation for most of them. And, you know, just to talk a minute about the needs of the insured, you know, we're here for you and you're there for your client. The trickle-down effect. And when we get a submission in, you know, like you guys, I'm sure everyone's busy. If you've got one that's time-sensitive, let us know. Let us know up front. We can usually meet your needs. And if we can't, we'll at least be able to let you know up front so, you know, there's no issue there. Whether it be, hey, I need this by tomorrow, or I need certain coverage, things like that. We mentioned flexibility earlier, and you know, think of this too. When I say flexibility, I'm talking about the coverage form. Say you've got a company, maybe it's an association that only needs D&O right now. Okay, great, we can do some D&O for you. 2 years down the road, there's 20 new employees. Maybe they've got a higher EPL exposure. Maybe there's some crime concerns. We can always look at that, whether it's endorsement or what have you, but keep that in mind because, you know, we're here to meet the needs of the client. And kind of with that said, that last bullet point there, package a deal that works for them. You know, Stuckey and Company here, we're not just a management liability house, we're a professional liability house, we're a commercial lines house, we're a personal lines house. Let us know what you need, and maybe we can put a nice package together for you. And then really, kind of continuing on that topic, meeting your needs. Most of the time, actually almost all the time, when we quote one of these policies, you're going to get some marketing material. You're going to get a specimen form. You know, we're not trying to, you know, be goofy or hide anything. We want them to see the specimen. If they want to review it with their lawyer, so be it. If you're not comfortable selling it, look at the marketing info or let us know. We can tailor some stuff to you. We have sample forms, apps, and supplements available for you. We're based in St. Louis, Missouri. We're about a half hour west of downtown. If you're local, let us know. We can come talk to you, sit down face-to-face and show you some of this stuff. Or if you ever visit, let us know and we can make arrangements. You know, and we deal with all different types of producers, but if some of you specialize in management liability, again, let us know. We can do some one-on-one, maybe some personalized webinars, get some conference calls going. And if any of you ever attend the Plus conference, we're there every November as well. Turnaround times, the Stuckey standard here is 24 to 48 hours. And I know many of you that work with me on some of the specialty products probably can attest, you know, some of them we can do in an hour, some of them take a couple weeks. Realistically, we can turn most of these around within a couple of days, usually quicker, but I do want to point out there in that second listing, you know, sometimes they do take longer. If there is a reason it needs referred, you know, it just is going to take a little bit longer, but realistically, it's about a 2-day turnaround. And then again, for you guys, when we do issue quotations, the pricing is clear, the commissions are always listed, specimen wording's given, and just a touch point there on the billing. Traditionally, most of these have been agency billed, and today I would say the availability for direct bill option is about 50-50. Just let us know. If the billing options are available, we're going to let you know when we quote it. If not, just ask and we can let you know what options are on the table. And then just kind of wrapping up, got some contact info there. Again, we are going to email everyone a copy of this presentation. Peggy went into some great detail, but you know, this is, like I said earlier, it's kind of, think of it as management liability 101. So if you have some specific questions, let us know. And then we actually, we've been getting several questions in. I'm going to address a couple of them. One person did ask if we have any MGA authorities, like on our other programs. And to answer that, Stuckey & Company does have full quoting, binding, and issuing authority with 2 carriers, those being ACE and Chubb. Kind of like the other programs, I mean, if it's something within our authority and it's, you know, a clean account, we can turn those out really fast. If not, you know, obviously there's a referral process in place. It might take another day or so. We also have some indicating authority with Philadelphia. And then some of the carriers we deal with, quite honestly, are increasingly speedy as well. So like C.N.A., for example, those are referral-based, but we can usually quote those the same day. So turnaround times hopefully are pretty good with those because of that. Another person asked, are you going to have more detailed webinars? Yes. Kind of like I just mentioned, this is Management 101. In the coming months and into 2013, we are going to be putting on some coverage-specific webinars that will go more in depth on each of those 5 topic points. You know, we'll talk about some underwriting preferences and needs and things to look for and you know, carrier trends and things like that. And we do have a bunch of questions. I'm not going to be able to get to all of these, so I will try to respond to some of these one by one later on. Peggy, I'll put you on the spot.
Sure.
A couple people asked about wage and hour.
Wage and hour. I see one specific question. Does C.N.A. cover wage and hour? We cover defense, depending on the state you're in and the industry. Currently, we're not considering wage and hour coverage for the state of California. Sorry, just too tough out there. Or healthcare. Healthcare, again, is just one of those industries that is extremely tough. So we're taking a more conservative underwriting approach to it. But on the average, we do offer $100,000 in wage and hour defense coverage on most industries.
Perfect. Thank you, Peggy.
Sure.
And with that, I, again, would like to thank everyone for your time. We definitely appreciate it and hope you learned something today. And special thanks to Peggy for joining us. I know she's very busy, but we definitely appreciate having her and hope everyone enjoyed the presentation. Have a good afternoon.